Hi, everybody. Today we are going to start our look into the judicial branch. And by doing that, we're really going to look at the construct of law and order. What is more important, the letter of the law or the spirit of the law? And a great way to really start that discussion is by looking at a famous case study that we look at, something called the case of the shipwrecked sailors. So I'm going to read this little description to you. 3 sailors were on an ocean-going freighter and were cast adrift onto a life raft after their ship sank during a storm in the Atlantic Ocean. The ship went down so suddenly that there was no time to send out an SOS, and as far as the 3 sailors knew, they were the only survivors of this ship. In their raft, they had no food and no water because the ship was sinking so quickly. They had no fishing gear or any other equipment that might have been used to get food from the ocean. After recovering from the shock of the shipwreck, the 3 sailors began to discuss what was going to happen to them. Dudley, who was the ship's navigator, figured that they were at least 1,000 miles from land and that the storm had blown them far off from where any other ships would normally pass. Stevens, the ship's doctor, indicated that without any food, they could no longer live for more than 30 days. The only nourishment that they could expect was one from rain that might fall from time to time in the middle of the ocean. The doctor, Stevens, noted, however, that if one of the 3 dies before the others, the 2 could live a while longer by eating the body of the 3rd. Ooh, this is getting dark real fast. But stay with us here. So the proposal is that we won't make it longer than 30 days if somebody who does die, right, then the people can eat that corpse. After 25 days, the 3rd sailor, Brooks, who by this time was extremely weak, suggested that they all draw lots. So they draw straws, right? They do sort of a lottery, and is one you don't want to win. If you do get picked, right, the loser will be killed and eaten by the other 2. The very next day, on day 26, lots were drawn and Brooks lost. After he lost, at this point, Brooks begins to object. He refuses to give consent. However, Dudley and Stevens decided that Brooks would die soon anyways, so they might as well just get it over with. After they thus agreeing, both Stevens and Dudley killed and ate Brooks. They ate the 3rd passengers. 5 days later, Dudley and Stevens were rescued by a passing ship and brought to port. They explained to all the authorities what had happened to Brooks, and after recovering from their ordeal, they were placed on trial for murdering Brooks. The state in which they were being held had the following law. Any person who deliberately takes the life of another is found guilty of murder. So the question is, what should happen to them? Is the situation, right, the letter of the law of what happened? They say, if you kill somebody, you kill somebody. You're going to jail for murder. Murder is murder. Or is the situation going to impact how we interpret laws? Law is so important to the foundation of any successful society. How it is implemented for citizens, how citizens interact with the law, and how the law protects people is so very important that we need to have a very good understanding of how we're going to interact with this story and interact with the rest of our world. So what should happen to these men? How should they be affected? How should they be arraigned? Should their circumstances be considered? Now, in the real case, this actually happens of a shipwreck from British ships, and they're brought back and they're put on trial. But the royal family is actually going to forgive or pardon them of any crimes due to their situation. But regardless, we still see a situation here where we really have to interpret. Do we follow everything down to the letter, or is there room in law for wiggle room? So, what are we going to really look at doing today? Today, we are going to really begin our series on the Supreme Court and the Bill of Rights, and we're going to look at this in various couple ways. Over our next couple of videos, we're going to start looking at Supreme Court cases, not ones like the shipwrecked sailors, some similar criminal cases, but ones that are in the United States of America, on American soil. So we're going to be looking at all of these cases. They are all real cases that you can look up. They're definitely going to be fun, but you're going to really need logical and focused rationale and argumentation in order to really be effective when we're looking at this. This will give us a deeper understanding of the subject matters we're talking about. However, today, in order to really interact with court cases in the Supreme Court and the Bill of Rights, we have to know what those are. First, we start with the Supreme Court, then we'll peel through the Bill of Rights in future videos. So, are we going to court yet? Not quite. So when we're talking about the court system in the United States, there's a hierarchy. A hierarchy is a system or a level in the way that things are being done. At the very bottom of the federal hierarchy, now understand what that means, federal, there is a state version of court systems as well, but the federal government, the highest level of court systems, there are what are called district courts. There are 94 different district courts that hear federal crimes all across the country. Then there are 12 appellate courts. So 12 that you can appeal to if you do not agree with your conviction, and if there is grounds for new evidence or that there is a fact of the case that was improperly judged, that you can prove and you can appeal to have another court hear that case with this new information to attempt to reverse that decision. And if that happens, they reverse the decision, you can have a new ruling. If nothing changes, but you still feel that your rights have been violated, then you can try to appeal to the only Supreme Court that we have. Supreme means the top. Supreme Court of the United States of America is the largest, or rather the highest ranking court system in our entire country. Nothing trumps a Supreme Court ruling. It is very unique. And this is really, when we talk about the judicial branch, this is it. These different courts that make this up. And usually when we're talking about the judicial branch, we specifically focus on one aspect. We're talking about the Supreme Court. In the same way that when we talk about the executive branch, there's more than the executive branch than just the president, but it's kind of the central focus of it. So the Supreme Court, as of 2020, when this video is being made, has 9 people sitting on it. That has been the consistent number in most of American history, but there is no set number outlined in the Constitution. Article 3 of the Constitution of the United States lays the framework for the Supreme Court, but it's very, very vague. And it's purposely vague because the conditions were terrible. It was extremely hot. It was extremely uncomfortable at the time that this was being written. And people were arguing constantly between different members of the United States, arguing about what a new constitution was going to look like, that eventually they came to an agreement that they're going to flesh out things as they go. And they left the Supreme Court very, very vague. So there's not much that we have written in the Supreme Court. All of their power is kind of given to them by themselves in future rulings and precedents that happened. But the things that we do know is that they are responsible for interpreting the laws of the Constitution and making sure that those laws that are passed, right, are actually in line with the Constitution, that they are constitutional, and that any action or court case or law is in alignment with that. These are not people that are assigning guilt or innocence. These are people that are judging on constitutionality. The highest branch of the federal government in the judicial branch is the Supreme Court. And on the Supreme Court currently, there are 9 judges. There is one judge, currently Chief Justice Roberts, right here. I have this kind of arrow, probably bad choice on a red background. Let me try yellow, right? He is the Chief Justice of the Supreme Court. He has no other really special powers except for the fact that he is sort of the voice for the Supreme Court. So if there is a major ruling, that he will typically read that, or he will begin some of these things. So he does not have any more power, even though he has an interesting name. The 8 associate justices all have the same amount of voting power as the Chief Justice. Everybody has an equal vote on the Supreme Court. And so they decide and they rule this group of 9 citizens that are elected, or rather appointed, nominated and appointed and approved by Congress, are going to be the ones that make these major rulings that are going to stand for the test of decades and decades. So when we look at what comes down to the Supreme Court and what sort of qualifications, right? We've looked at there's various age and citizenship and length of term qualifications or restrictions for, say, like the president or a member of Congress or the Senate. To be on the Supreme Court, there is no age limit. You could be an infant, right? And you could be on the Supreme Court. You could be 103 years old and you could be on the Supreme Court. Citizenship or residency, there is no restriction or qualification that to be a justice of the Supreme Court. And the length of your term, how long do Supreme Court justices serve? They serve for life. There are no explicit requirements or qualifications for a Supreme Court justice or a federal judge in the U.S. Constitution. The Supreme Court judges, the highest court in the land, they don't have to worry about re-election. So they're not making decisions that are just going to make people happy and make political moves. They're making the best legal decisions that they believe to exist. So they serve until they quit or they die. And so the way that this works is the President of the United States can appoint nominees to be a Supreme Court justice. The most current one is a man by the name of Brett Kavanaugh. He went through a volley of different analyses and interviews and kind of having to speak before different committees. Members of the House of Representatives and the Senate, and then they vote and they decide, Congress decides, does this person pass the test? Are they going to be voted through to the Supreme Court? If they vote yes, they're on. There's nothing you can do about it. You could impeach a Supreme Court justice if they do something improper. However, the length of these terms is for life. So a president, right, say Trump nominates Kavanaugh, right, and he gets him put in office. He put him in office a couple of years ago. He could serve, Kavanaugh is relatively young in the political age. He could serve for the next 20 to 30 years, right? He could still be serving as a Supreme Court justice in 2050, right? Put that in perspective. In 2050, it's 2020 right now, 30 years in the future, he could still be making Supreme Court decisions. That's why this branch is so important, is because of the ramifications about what these decisions will mean in the future. So you don't need any skills, any experience requirement in law. You could be a random person off the street, but again, will Congress actually approve or ratify your position? No, right? You don't even need a law degree to be on the Supreme Court. But again, most of these people would have to have it. These haven't happened before without it, but you would need some sort of a qualification probably for Congress to actually approve your nomination to actually hold that office. Now, as I said before, federal judges are appointed by the president. Barack Obama has appointed Supreme Court Justice. Donald Trump has appointed a Supreme Court Justice. George W. Bush. There's been many different presidents that have nominated and gotten Supreme Court justices approved. That's the big key, though. So a president can put up a choice, but because they don't want a single branch to have full control of the government, if the president could put up whoever they wanted without checking or approval, that could really skew the federal government for many decades to come. So the president selects someone that they would like or that they suggest, and the Senate has to approve of it. And if both the executive branch and the legislative branch approve on that choice, they get put up into the judicial branch after they take an oath. So that is the way that justices are selected. There's not an election process, right? It's a nomination process. When we're talking about the Supreme Court, we also have to talk about jurisdiction. Jurisdiction means, in simple terms, does the court have the right to hear and rule on a certain case? So this is the book definition of the authority to act, hear a case, investigate, or make an arrest. So does this court have jurisdiction to cover anything in particular, right? When we're talking about federal courts, we have something called original jurisdiction, right? There are different types of court cases, but what the Supreme Court deals with, they are not dealing with necessarily murder cases. They are not dealing with necessarily cases involving kind of grand larceny, which is the theft of large amounts of money. They deal with cases that are on the claim that constitutional rights are being violated. They do not side guilt or innocence. They do not side jail time. They do not decide penalties. What they decide is if a ruling is legitimate or not. If a ruling or an action violates a constitutional amendment, strips away an amendment right of a citizen that all people are entitled to as citizens of the United States, then that action, that ruling, or that law becomes null and void. It's voided immediately. A conviction could be completely vacated and removed. However, if a ruling is upheld, then the sentence still stands. So we have different types of courts. We have the district courts and we have the Supreme Courts. So when we're talking about types of disagreements, there are some cases that can go immediately to the Supreme Court, but it's usually the highest ranking appellate court, and it's very rare that a case would immediately go there. We are talking about things like district courts are going to deal with crimes in a state, right? So extreme crimes in a state, you can appeal to a federal court. And then if you don't like that ruling and you have enough evidence that courts are willing to hear it, you can appeal all the way up to a federal appellate court and the U.S. Supreme Court. The Supreme Court case, however, will hear cases immediately. They have full jurisdiction in arguments between states. So for example, if there is a crime in the state of Massachusetts, then in Massachusetts, they're going to deal with that crime. But if there is a crime or an issue between the states of Massachusetts and Rhode Island, who's going to hear that case? The federal government will deal with that crime or this claim of violation of rights between states. And so our U.S. court system is very intricate. There are multiple levels. There's a military court, a court martial you may hear, right, that is separate from a different kind of court system than anywhere else. And then you have high-level state courts. There's a state Supreme Court. So there's a Rhode Island Supreme Court, Connecticut Supreme Court, California Supreme Court, Texas Supreme Court, North Dakota Supreme Court for these individual states at the highest level. And then there are ways to kind of exceed those and you go up to the federal level beyond that. There are things dealing with kind of the different parts of the federal circuit, whether it's dealing with international trade or veterans appeals, tax courts, all these different things. But at the very, very top dog, and it's kind of like how the Constitution of the United States is relative to any other state law, it is the highest level of a ruling in the United States of America. And because it is so high ranking, nothing can trump it. So these decisions are so, so important. These set the precedent for decades and centuries to come in U.S. history. Now, when we're talking about appellate, if you appeal to something, which means you want something to happen, we're talking about appellate courts. They have the authority to hear court cases that people want a second opinion on. So say you go to court, right? You go to a district court for some sort of crime and you have a ruling and you feel that that ruling is unjust and improper. You can appeal to a higher court to have them re-look at this case. And if they agree to it, they can potentially have a different ruling and it could overturn a ruling perhaps. There are different types of courts and different types of rulings and issues that they deal with. However, the appellate courts are the most common that we're talking about. So there's a district level court where they believe that there's an error in the case, and the appellate court is going to look at that court case again. They will rehear the evidence or at the admission of any new evidence, a retrial essentially, and based on that information, they may come to a brand new conclusion and a new penalty or a removal of any penalty. Then at the top level, the highest level appellate court, you can appeal all the way up to the U.S. Supreme Court. So if you go to an appeals court and you still don't like the ruling and you still feel that's unjust and you think there are grounds of constitutional rights being removed, you can appeal all the way up to the U.S. Supreme Court. They will not hear every single court case that comes to them. They will pick and choose which cases they think have merit or have a legitimate claim, and they will decide on those cases and only those cases for that year. One of the most important things to understand about the Supreme Court is their powers and what can they actually do. So the power of the Supreme Court is really kind of summed up in one particular phrase, and that phrase is called judicial review. Judicial review is a term that comes from, or a power that comes from, a court case in the early 1800s, 1803, a court case called Marbury versus Madison. And in this ruling, the Supreme Court makes a stand that they, being the top level of the judiciary system in this country, that they have the right and duty to uphold the Constitution of the United States by whatever means necessary, right? Whatever they must do, right? That even if it's a presidential action, even if it is an action by an individual citizen, whether it's a law that Congress passed, that they have the right and duty to strike that law down. So the power of judicial review gives the Supreme Court the power to declare any law unconstitutional. If they declare and they decide that it violates the United States Constitution, any aspect of it, that they have the ability to make it illegal, null and void. They also have the power to declare any executive action, any presidential action unconstitutional. So the judicial review power gives the Supreme Court the ability to check any other branch's power. It also allows really the United States, outside of judicial review, the Supreme Court has the power to settle any disputes involving the United States. So whether there is, for example, in the Watergate scandal, President Nixon dealing with his response to the high-level federal courts in Nixon versus United States, also settling disputes between different states. So each state has their own court system in which they can handle laws and that they can handle rulings. However, what happens when, as I said before, say there is an issue between the state of Massachusetts and the state of Rhode Island, or between the states of North and South Dakota, or between the state of Texas and Oklahoma, or any state for that matter, who's going to settle that case, right? What was the fair way or a fair court, unbiased court that's going to be set up there? Well, you're going to have to take that to the federal level. Who is going to decide on that? The highest level of that being the Supreme Court. It's the last stop. Once that ruling is made, that's it. Now, there are some limits, and it sounds like the Supreme Court and the Judicial Branch can kind of do and check any power they want, but they really can't. So the Supreme Court can check different rulings or judgments that are made. However, they can't do everything. There is a ruling or a precedent called ex post facto, right, which is Latin for after the fact, right? Essentially is what that breaks down to, right? Right. You cannot take action after, right, something has happened. So say that it becomes illegal to use a cell phone. Say that cell phone usage is connected to some terrible disease, or there's some sort of action connected to it, and they make using your cell phone illegal, right? Now, all of us here have used a cell phone in the past. What ex post facto means is they cannot punish you for an action in the past if it wasn't illegal then. So if using my phone back then wasn't illegal, right, I can't get in trouble for using that in the past, even if they pass a new law now. Now, if they pass the law and I do it again, yes, I can get in trouble. But I followed the laws at the time. So I didn't commit a crime when a law was in effect. There's also something called a writ of habeas corpus. It is a must that each court system, regardless of level, that you require police to bring a prisoner to court, explain why they're being held, right? That they can't just lie to you and say you don't know, like they can't tell you why you're not here, so you can't defend yourself or you can't try to explain your innocence. They must legally explain to you why you are being detained and for what you are being detained. They can't just detain you for any reason, right? You have the right, the freedom, the kind of the body of a written body of proof, right? Habeas corpus of what you are able to do. So they can't just say, yeah, he looks guilty, or we're not going to tell him until after the trial's over. They have to tell you up front so that you have a reasonable right. You are innocent until proven guilty. And lastly, another limit is something called a bill of attainder. A bill of attainder is any sort of law or action that targets a specific individual or group. So certain laws cannot be put in place to target specific individuals without a fair hearing in court. You cannot just punish someone or put a target on their back because you want to. So these are all limits from protecting not only laws, because a lot of these deal with the legislative branch, but how laws are being ruled upon, how the people are being judged. There are certain rights that must be obeyed at all times. There are a couple other key vocab terms that I really want to drive home. Some of these we did talk about today already, and some of them we did not. The first one that I really want to make sure that we understand is the term judicial review. That a court can review any federal or state law to see if it is in agreement with the U.S. Constitution. And if it is not, they can strike it down as unconstitutional. It becomes null and void. It disappears. If it is in line, it stays into effect. There is also a precedent called stare decisis, which is another Latin word, but this means let the decision stand. The legal precedents of past court decisions are kind of binding, which means that they impact future court cases. So when you make a ruling, you can't just make a ruling for one individual case. If you are following the rule of law, you must be consistent, right? That if you are going to strike down this type of speech, you have to always strike down that type of speech unless a further court case comes around, that your ruling, your decision stands as a precedent for the future, that court cases dealing with similar facts and issues are dealt with in a similar manner. So you really have to be consistent. And so these Supreme Court justices also cannot just make decisions in the temporary, but they also have to think about the precedent that their decision could make going forward. There are things called written briefs. So when a court case is being heard, legal experts or lawyers have to write what is called a brief. Now, briefs are not short. They are a written summary of the court case, why they're being argued, that are presented to the court. You do not have long in the grand scheme of things to really present your court case in your written brief, your oral brief to the court. But after it's presented to the court, then the Supreme Court will consider all of the evidence, they will think about it, and then they will write a decision. Now, on the Supreme Court, there are 9 individuals, 9 justices. The way that rulings are decided are through majority rule. So of those 9, if 5 or more judges agree on a certain issue, that becomes the ruling of the court. But not everybody is going to agree. Not everybody is going to agree for the same reason. So, for example, you can have the majority opinion represented here by the green, right? And the green and the blue here, the majority is what most of the voters agree with, what most of the judges agree with. However, right, so the green may agree that an individual's rights were violated, and the red says no, they were not. But what about the blue person? Right? So the blue individual here might be what we call the concurring opinion, that they agree with the majority, but they agree for a different reason than the other 4 have stated, so that they also agree, but they give a different opinion on the court matter. So they will typically explain that. It's called a concurring opinion. And there are people that disagree with Supreme Court rulings. There are justices that end up on what we maybe just simply call the losing side, but it's really not a losing side. You're not wrong. You just do not fall in line with the majority at this time. For example, in Supreme Court cases in the past, there have been many different precedents that have been set. Famous Supreme Court case, Plessy versus Ferguson in the 1800s, outlines that segregation is 100% legal in the United States and that there is no precedent in the Constitution that you have to force integration. But in later years, right, there were people at that time, judges, that disagreed with the majority opinion. But in later years, say 1954 with Brown versus the Board of Education ruling, that they overturned Plessy versus Ferguson, that they mandated all public schools be desegregated and integrated. So just because you are on the minority or the dissenting opinion does not mean that your opinion is wrong. It does not mean your opinion is not valid. It means that you did not come down on the side of the majority, and so your argument does not prevail. These are our major key terms. We are going to review these in our next video, but I really want to make sure that they are out there, that they are available for us all to really think about and digest. Other than that, we're going to do a quick little review here for us to make sure that we got the major pieces about what the Supreme Court is, because this is going to be our focus moving forward. So who is on it? How many justices are there? 9. 9 is the magic number. 8 justices and 1 Chief Justice. How do they decide who wins? They take a vote. Majority rules, right? The closest of a vote that can be is a 5-4 decision. 5 was the majority, 4 was the dissenting opinion. What do they decide on? So what are they really deciding? What are they choosing? What are they arguing? They are deciding on constitutionality. They are deciding, was someone's rights, constitutional rights, violated? Is the law, right, a violation of these constitutional rights? Was the search of the process a violation of their constitutional rights? They really do not, and this is so important to understand, these are people that are not deciding penalties and punishments. They are not deciding guilt or innocence. They are not deciding the death penalty. They are not deciding life in prison. They are deciding, were someone's rights, constitutional rights, violated. Really, really important. And lastly, how powerful is a Supreme Court ruling? A Supreme Court ruling is final. These are the highest rule in the land. There is nothing that can trump a Supreme Court ruling except another Supreme Court ruling. So it's really important to understand the vast importance of the Supreme Court to this country and why they are so important. If you have any questions about the Supreme Court and the function of the Supreme Court, feel free to drop a comment down below and I will get back to you as soon as humanly possible. But other than that, stay tuned. In our next video, we are going to dive into the Bill of Rights and we're going to use this content from this video in the Supreme Court to really start to digest this content a little bit more. And we're going to start sifting through court cases that the Supreme Court has to rule on and how do they actually decide? How difficult are they? And what do they use as evidence to back their decisions? Take care.